Okay, so we're diving into something pretty interesting today. Um, have you seen this whole thing with Studio Ghibli and AI art?
Yeah, it's really blowing up right now.
Yeah, you got those incredible films like My Neighbor Totoro, Spirited Away, all the classics.
Clueless.
And now people are using AI image generators like ChatGPT to create art that has that really unmistakable Ghibli feel, those lush landscapes, whimsical characters,
Mm.
the whole vibe.
It's fascinating, right? Like instantly recognizable.
Totally. And this brings up such a huge question like, can an artistic aesthetic, a vibe, even be protected as intellectual property? Like we protect trademarks or patents.
Yeah, that's the core of it, right? Can you actually own a feeling, a style? Especially now that AI can replicate it so well.
And it's no secret that Miyazaki and Studio Ghibli are not exactly thrilled with this whole thing.
Yeah, Miyazaki's even called it an insult to life itself.
So you have this real clash between this powerful new technology and these incredibly strong artistic sensibilities.
Exactly, a real push and pull between innovation and tradition. And for this deep dive, you've brought in some really interesting sources that go beyond just like the initial reactions.
Yeah, we're going to try to unpack the legal side of this. Like, how do you even protect something as intangible as a feeling in a world where AI can learn and reproduce styles so easily?
It's a whole mess of copyright law, trade dress, even the potential for licensing that Ghibli
A
style.
real collision of art technology and the law.
Absolutely.
So let's start with that Ghibli vibe itself. Like, what even is it? It's so much about a feeling, right? Those beautiful hand-drawn worlds, the unique characters, the sense of warmth and wonder.
It's hard to pin down, right? Like, how do you define that legally?
Exactly. And our sources pointed out that current intellectual property law, particularly copyright, really focuses on protecting concrete expressions of an idea.
Like a specific character design or a particular scene from a film.
Right, like copyright would protect the sheet music and lyrics of a song, but not the entire genre of like jazz or something.
Exactly. You can't copyright a genre.
And our sources use the example of Roy Lichtenstein. He was able to use that comic book style in his art without infringing on any specific comic panel.
Right. He was riffing on the aesthetic, not directly copying.
So just suing someone for creating something that feels like Ghibli under copyright law,
Mm-hmm.
that's probably not going to fly.
It'd be really tough to win that case.
And then there's this added layer of complexity with AI, right? It's not like directly copying a single Ghibli film.
It's more like it's been trained on this massive data set of images, which probably includes a lot of Ghibli stuff, and then it's learning the patterns and synthesizing a style.
So it's not copying, it's creating something new,
Yeah.
but based on all those influences.
Right, and that gets us into this whole murky area of fair use. Is the AI's output different enough, transformative enough to not be considered infringement?
We've seen similar debates in music with sampling.
Oh, absolutely. And now AI art is pushing those boundaries in the visual realm.
So if copyright isn't the clear answer, what other legal avenues might Ghibli consider?
Well, one interesting concept is moral rights. This is a bigger deal in some countries outside the US, like Japan and Europe.
Yeah.
It's the idea that creators have the right to protect the integrity of their work and their artistic reputation.
So Ghibli could argue that AI mimicking their style, even without direct copying, is harming their artistic identity.
Exactly. But the thing is, moral rights are much weaker in the US legal system.
Right, so not a slam dunk case here.
Probably not.
What about trade dress law? Our sources brought that up as a possible way to protect a vibe.
Yeah, trade dress is interesting. It's basically about protecting the overall look and feel of a product or brand to prevent consumer confusion.
So like the shape of a Coca-Cola bottle or the red soles on Louboutin shoes.
Exactly. Those are distinctive design elements that have become so strongly associated with a brand that they have legal protection.
So you're saying the Ghibli vibe could be argued as a kind of brand identifier.
Potentially. The argument would be that their visual style is so recognizable that AI-generated Ghibli-esque images could mislead people into thinking it's official Ghibli stuff.
But are there hurdles with that approach?
Oh yeah, big ones. Trade dress usually requires proving acquired distinctiveness, meaning that consumers have come to automatically associate that specific look and feel with that brand over time.
So like Apple's minimalist design aesthetic, that's become a recognizable marker of their brand.
Right, but applying that to an artistic style rather than a physical product, that's a huge leap.
Like trying to patent the feel of a world-designed machine, not just the specific parts.
Exactly. And one of our sources said it's like, legally the law isn't really equipped to handle that yet.
So trade dress is a maybe, but a long shot.
It would be a tough case to make.
Okay. But our sources pointed to another legal angle that might be more promising for Ghibli. going after the AI training data itself for copyright infringement.
Yeah, this is where things get juicy.
Instead of focusing on this nebulous idea of a vibe, they could go after the fact that AI generators are trained on massive data sets that almost certainly include Ghibli's copyrighted films, stills artwork.
And that's a much more concrete legal argument.
Right. It's like OpenAI used Ghibli's protected works without permission to develop a tool that's now making money off of mimicking their style.
It's about the unauthorized use of specific creative works.
And copyright is all about protecting those specific expressions.
Every frame of animation, every character design.
So if Ghibli can prove that OpenAI used their copyrighted material to train the AI, they have a strong case for infringement.
Especially since OpenAI is profiting from it.
But what about OpenAI's defenses? Our sources mentioned a few possibilities.
Well, they could try to argue transformative use.
Maybe.
That the AI's output is sufficiently different from the original Ghibli works. That it's not just a copy.
A new creation inspired by, but not infringing on the original.
Right. They might also point to the black box nature of AI.
Like, it's so complex, it's hard to prove exactly how the AI arrived at its output.
Exactly. It's like reverse engineering a product, but you can't see the blueprints.
Tricky. But if Ghibli could somehow show a clear link between their works and the AI's ability to replicate their style, that could be a winning argument.
It would be compelling for sure.
This whole legal landscape feels like a minefield.
It really is. Technology is outpacing the law in a lot of ways.
But then our sources offered up this really fascinating alternative for Ghibli.
All right.
What if instead of fighting AI, they actually embraced it through licensing?
That's a really interesting idea.
Right. Instead of battling it out in court, which could be costly and with uncertain results, they could license their aesthetic, or more specifically, their library of films and artwork, to companies like OpenAI.
Turning a potential threat into a new revenue stream.
And how would that actually work?
Well, OpenAI could pay Ghibli a licensing fee for the right to train their AI on Ghibli's copyrighted material.
So basically paying for the privilege of learning from the masters.
Exactly. And that fee could be based on usage or revenue generated by the Ghibli-style AI.
They could even co-brand an official Ghibli AI generator.
Yeah, and Ghibli gets a cut of the profits.
It's like instead of just selling Totoro plushies, they'd be licensing the essence of Totoro-ness.
You got it. And Ghibli could also set terms in the license, like limiting the types of output.
So no AI-generated Ghibli feature films without their explicit consent.
Right, or even retaining some artistic control, maybe giving Miyazaki veto power over anything that doesn't feel authentically Ghibli.
That sounds like it gives them some power in this wild west of AI art.
Definitely. But our sources also brought up some potential downsides.
Yeah, like what?
While some fans might see it as selling out.
Especially with Miyazaki's reputation for artistic integrity.
Exactly. And there's also the challenge of enforcing the license as AI evolves and gets trained on new data.
Can you really keep the AI in its Ghibli lane, so to speak?
It's a valid concern, but from a business standpoint, licensing could be a smart move.
And then our sources took this idea of licensing even further, suggesting that Ghibli could use it to actually manage their IP in the age of AI, like regulating the AI black box.
It's about moving beyond just trying to prevent AI mimicry and instead shaping how their aesthetic is used.
So setting those hard limits, like no AI Ghibli sequels, and ensuring that whatever the AI creates aligns with their artistic vision.
Like giving OpenAI a Ghibli-approved filter.
And one of our sources, who's an engineer, compared it to licensing CAD files, but locking the design software so you can't make unauthorized changes.
A really apt comparison. Ghibli gets revenue, maintains some artistic control, avoids legal battles.
But there's a lot of trust involved, right? Trusting that OpenAI won't dilute that Ghibli magic over time.
And there's always the risk of fans being disappointed if the AI art doesn't live up to the hand-drawn originals.
It's a gamble, for sure. But then our sources propose another way Ghibli could use AI as a tool for things like product development and market research.
That's right. Think of it like this. Ghibli could analyze what people are asking their AI to create.
Like Totoro in a cyberpunk city or something.
Exactly. And if they see certain themes popping up consistently, that could give them ideas for new projects or merchandise.
It's like crowdsourcing inspiration, but with an AI twist.
Exactly. The AI becomes this real-time R&D lab, testing out concepts and gauging fan interest.
But as our sources emphasized, Ghibli would need strong data ownership agreements to prevent the AI company from running off with all that valuable fan data.
Absolutely. And then there's the question of whether Miyazaki would even be open to this kind of data-driven approach.
Right, he's all about artistic vision, not chasing trends.
It's a valid point. This whole situation with Ghibli really highlights a dilemma that so many major IP holders are facing.
Like Star Wars, D&D, Marvel, Warhammer.
They're all wrestling with this tension between preserving the original creator's vision and allowing the property to evolve.
Like how much control do you maintain versus letting go and allowing for new interpretations?
It's the classic balance between legacy and evolution.
And we've seen different approaches, right? Star Wars has had its share of controversy with both prequels and sequels, while fan-created content and AI art are exploding.
D&D has become more open to player creativity and third-party content.
While Warhammer has been much more protective of its lore.
And then you have Marvel, this massive commercial machine that's arguably prioritized market appeal over strict adherence to any one creator's vision.
Each approach has its trade-offs.
Too restrictive, and you risk irrelevance.
Too open, and you risk diluting what made the property special in the first place.
It's a tough needle to thread.
And for Ghibli, there's this added layer of how do they sustain that Ghibli vibe in a post-Miyazaki world?
Our sources framed it as a problem statement. How can Ghibli maintain its legacy after Miyazaki without losing its essence?
Even without AI, that's a huge challenge.
Right. So the work to be done involves first really defining what that Ghibli vibe is.
Like codifying it somehow.
Exactly. So it can guide future projects, whether they're human-made or AI-assisted.
Then it's about adapting to new technology like AI, potentially through licensing, but with strict guardrails.
And crucially, having a plan to deal with potential risks like fan backlash or technical hiccups.
One source compared it to an engineering challenge.
Maintaining the core specs, but upgrading the tools and constantly testing the results.
And then our sources threw in this completely unexpected curveball. The White House using an AI-generated Ghibli meme to depict the deportation of a fentanyl trafficker.
Talk about a jarring juxtaposition.
Yeah, it's like what this beloved whimsical style used to depict something as serious and controversial as deportation.
Our sources really zeroed in on two main criticisms.
The first being the meme itself just wasn't very good artistically.
It felt uninspired, just hopping on a trend without adding anything new.
And the second much bigger criticism was the insensitivity of using the Ghibli style for something like deportation.
Like, deportation is not Ghibli, as one source put it.
The lightheartedness of the Ghibli aesthetic just clashes so hard with the real-world consequences of deportation.
It's tone deaf.
And it also seems to contradict what Vice President J.D. Vance has said about prioritizing the deportation of violent criminals.
Right, it raises questions about consistency and messaging.
This whole thing really shows how AI art can be used in ways that are totally unpredictable and potentially problematic.
It raises questions about context, intent, and responsibility.
And speaking of legal complexities, our sources then briefly touched on the topic of anti-libel injunctions and free speech.
It's a bit of a tangent, but it relates to this broader issue of how we regulate content in the age of AI.
So while we've been focusing on intellectual property, this White House meme incident brings up these fundamental questions about free speech and when it can be legally restricted.
The legal excerpts you shared highlight the historical reluctance of courts to issue what are called prior restraints on speech.
Basically trying to prevent speech from happening in the first place.
Exactly. There's this strong legal tradition of allowing speech, even potentially harmful speech, to occur, and then dealing with the consequences afterwards.
So instead of censoring beforehand, you address any harm through legal action after the fact.
Right. It's about protecting free expression and avoiding censorship.
And the legal excerpts delve into these ongoing debates about the level of proof needed to restrict speech, the role of juries in libel cases, and this principle that equity will not enjoin a libel.
It gets into complex constitutional questions and concerns about fairness, especially for people who can't afford to fight expensive legal battles.
So even though there have been cases where courts have issued anti-libel injunctions, there's no clear consensus on their legality or appropriateness.
It's a murky area of the law, and AI-generated content is just adding to the complexity.
So to bring it all back to where we started, this deep dive has really been about this fascinating intersection of AI art and intellectual property.
We've seen how AI can now convincingly mimic the style of something as unique and beloved as Studio Ghibli.
And this raises all these tough questions about how we define and protect artistic aesthetics in a world where algorithms can learn and reproduce them.
We talked about the limits of copyright, the possibility of using trade dress law, the potential for licensing agreements.
We also saw how AI art can be used in unpredictable and potentially controversial ways, like with that White House meme.
It's a reminder that technology often outpaces our ability to fully grasp its implications.
And in the end, it all comes back to this tension between artistic integrity, legal protection, and the evolving relationship between creators and their audiences in the digital age.
It's a complex landscape, and there are no easy answers.
So, as AI continues to blur the lines between imitation and creation, it forces us to ask some big questions. How should our laws and cultural norms adapt? How do we protect artistic identity while fostering innovation? And should a vibe, a feeling, be something you can legally own?
These are questions we're going to be grappling with for a long time.
And as always, we leave you with those questions to ponder. That's it for this deep dive.
Until next time.